much. Professor.
Thank you very much for inviting me to your committee today. I'm here to speak on a fairly narrow point relating to potential conflicts between the bill, once it's enacted, and proposed provincial legislation in, as I understand it, Manitoba, but also Quebec, and I'll focus on Quebec since I've looked at that bill that is presently before the Quebec National Assembly. So I'll premise my remarks simply by saying that I am not an expert in criminal law, and nor have I studied the issue of cannabis regulation or decriminalization in any depth. I teach constitutional law at McGill, and I'm simply coming at this issue from that perspective, the perspective of somebody who has thought a bit about federalism and the division of powers in Canada. So the specific question that I understand that your committee has some interest in is the question of home cultivation of cannabis. The bill will provide for a general prohibition on home cultivation of cannabis, with an exception for people growing 4 or fewer plants at home. Quebec has a bill before the Quebec National Assembly that would prohibit home cultivation of cannabis. In my written submission, I've quoted the clause in the Quebec bill on this point. I'll just read it to you quickly. It is prohibited to cultivate cannabis for personal purposes. Anyone who contravenes this rule by cultivating 4 cannabis plants or less in their dwelling house commits an offence and is liable to a fine of $200 to $750, and the amounts are doubled for subsequent offences. So that's the proposed Quebec rule. Very quickly, I'll just summarize my conclusions, and I can provide further explanations later, or you can have a look at my written submissions. I think both the federal rule on cannabis home cultivation and the proposed Quebec rule on prohibiting home cultivation are constitutionally valid. I don't think there's a validity question here. It's a paramountcy question. As you know, when a valid provincial law and a valid federal law operate or are arguably operate on the same point, the question of conflict may arise, and the paramountcy rules deal with that conflict. My own view is that on a standard or narrow reading of the case law on this point, it might well be possible for the courts to find that both of these rules are operable simultaneously. Though the result of that would be that people in Quebec, at least, would not be able to cultivate cannabis at home. However, I think, and I don't mean to be waffling on this point, but I have to acknowledge there is a strong argument going the other way, to the effect that complying with the provincial rule would undermine one important purpose of the federal rule, which is to address the illicit production of cannabis. And I think, as I understand it, the reason for allowing some small amounts of home cultivation under the proposed federal rule would be to undercut demand for illicit cannabis. And it is one method of addressing a serious problem. Would the Quebec rule frustrate that federal purpose? It arguably would. And for that reason, it may well be found that the Quebec rule is inoperable. But as I say in my written submissions, there's some question about how that argument would work and whether it would involve extending the jurisprudence on the Canadian criminal law power to a point where it had not previously gone before. So I'll just stop there for now.
Thank you. I'm sure there will be questions. Senator Boisvert.